After discovery is completed, the case is set for trial. Trial preparation is the hardest and most serious aspect of the case. At trial, each side calls all of its witnesses to testify on the witness stand and presents all of its written evidence as well. A general overview of the trial looks something like this. Within the month prior to the trial, both parties will present motions to the court to either try and win their case without a trial, or to otherwise control what will happen at the trial, and what evidence is admissible and what isn't. These are called pretrial motions. The court will hear and rule on all of these. The lawyers do all of this on their own, and the clients are rarely needed or involved. Most medical cases use a jury, and so the next order of business is for the trial to start and a jury to be picked. At this point, the clients must be in court. Once a jury is picked, each side gives an opening statement. This is not evidence, but rather is each side's story of what they will try to show really happened in the case. Since you are the victim plaintiff, you always go first in court and the defendant goes last. The idea is that the plaintiff has the burden of proof and so must go first. The burden of proof means that the plaintiff must prove each and every element of the case. The defendant doesn't have to prove anything. The defendant can stand mute or present evidence rebutting the plaintiff's case. That is the defendant's choice. But the plaintiff cannot, as it is the legal burden of the plaintiff to proceed or prove the case. The plaintiff must show that it is more probably true than not that the plaintiff is entitled to recovery. After this, the lawyers ask questions of their own witness. This is called direct examination. But unlike a deposition, the opposing lawyer always has the right to cross-examine each and every witness after direct examination. The idea here is to bring out things the other side left out or covered up or even lied about so the jury can see. Cross-examination by a well-prepared lawyer has been called the single most effective method of deriving the truth that mankind has ever developed. But I will stress again, an effective cross-examination is no better than the amount of effort your lawyer has put into researching every last bit of evidence in the case. A good cross is not possible without good preparation. One aspect of trial you should be very familiar with is the impeachment tool. In short, impeachment of a witness means the witness was caught in a lie right in front of the jury, where he said one thing under oath at the deposition, and then a different thing under oath at a trial. This is never good for your case, so you must thoroughly read your deposition before testifying at trial, to make sure you know what you said. Here's how that happens. Let's assume the medical expert witness hired by the defendant insurance company testified at the deposition about some crucial but complex medical point, thinking the plaintiff's lawyer wouldn't understand. Assume further that you had retained a medical expert to attend the deposition to assist your lawyer. Now, when the case is at trial, the defense side tries to change that medical point to improve their case and is unaware that the plaintiff is ready for this. This is when the medical expert, also present at the trial, will catch the lie and so advise your lawyer immediately. When your lawyer cross-examines this defense expert, your lawyer can pull out the deposition testimony and then show the jury that the testimony in court has changed from the testimony at the deposition. This is devastating to the credibility of the defense expert and very helpful for the plaintiff's case. After all of the above, the lawyers will give a closing argument about the case. This is where they remind the jury of what the evidence showed and try to argue how that evidence supports their version of the case. After this, the judge will instruct the jury and send them out to deliberate. Once the jury comes to a unanimous decision, they come back into the courtroom and it is read aloud. If the jury finds for the defendant, the case is over. And if the jury finds for the plaintiff, then they must also state the amount they're awarding. If the losing party feels that it didn't get a fair trial, an appeal can be taken. Remember that just as in a deposition, your lawyer should and most likely will thoroughly prepare you for trial. In general, you should answer the questions honestly and to the point. Rambling on a long narration is unwise and can hurt you, as you may say something inadvertently that wasn't asked or that can be taken the wrong way by the judge or jury. Answer the question and only the question, and then be quiet. Do not be embarrassed if no one is talking. Just wait for the next question and remain quiet. Always wait a brief second before answering a question to allow time for your lawyer to object if needed. If your lawyer objects, you should immediately stop talking and let the objection be made. The trial judge will rule on the objection and instruct you on what to do next. In general, the objection will either be sustained, meaning the court agrees with your lawyer's objection and is ordering the cross-examining lawyer to drop that question, or it will overrule the objection and instruct you to answer the question. Avoid making faces or showing too much emotion in court, whether you're on the witness stand or at the counsel's table. The judge and jury are always watching you, and proper courtroom decorum will serve you better than visible emotions and frustration. Finally, all trials have ups and downs from minute to minute and day to day. That's how it goes. Each side is going to make some points at some time or another. There literally is no foolproof way of watching the judge or jury or trying to predict how they're thinking. You just prepare hard and do what your lawyer advises. You just worry about putting on your case the best you can, and just let the jury do its job. As they say, do such a good job that you can't be ignored. Like anything else, you must prepare, prepare, and prepare if you want to win. This is never a casual undertaking any more than the Super Bowl is to the NFL. MedWitness Limited does work with lawyers to thoroughly train and prepare your expert medical witness for trial. The medical expert, just like you, is not a lawyer and needs to be prepared as much, if not more, than anyone else, because he is the witness who has to get all of the medical points across and stand up to cross-examination. It is he who must outdo the opposing lawyer and the opposing medical expert. We have vast experience in preparing for this process. MedWitness Limited can also make arrangements to provide a consulting medical expert at trial who does not testify, but who helps the lawyer medically.